This case set for oral argument, consolidation of cases 18CA011386, which is Viola Associates versus Firelands Local School District, and 18CA011387, Viola Associates and the Lorain County Auditor Board of Revision. Firelands have waived oral argument, so Viola will have, the appellee will have 15 minutes, and the appellant will also have 15 minutes. Lorain County Auditor Board of Revision. Now, the appellant may reserve up to 5 minutes if you'd like for rebuttal. I would remind you that the arguments are recorded and placed on our 9th District's YouTube channel, so we ask that you speak from the front podium and keep your voice up. We've read the briefs and we're ready to proceed if you are. Thank you. So, will you be reserving time?
Yes, please.
Okay.
Thank you. May it please the court, I'm Kelly Gorey with Rachel.
Oh, we're going to do the front podium, I'm sorry.
Oh,
Yeah.
sorry.
Our front podium is supposed to be yours.
Yeah.
My apologies to everyone who said that.
That's okay. We
Thank
just
you.
want to get a good recording of you, so.
I like being closer to you.
Okay.
Thank you very much. May it please the court, I'm Kelly Gorey of Bridge and Gillis Law Group, and I'm here representing the appellants, Lorain County Auditor and the Lorain County Board of Revision. We are here today to discuss the proper classification of approximately 100 acres of greenhouses that are located on 4 parcels of real property that total approximately 186 acres. The Board of Tax Appeals below determined that these entire greenhouse structures are business fixtures and therefore classified as personal property, not subject to the real property tax. Both the county and the Firelands Local School District have appealed. We're contending that the Board of Tax Appeals made numerous errors of law, specifically in the construction of the business fixture and the real property definition statutes. Relating to the real property definition statutes listed in 570102, the Board of Tax Appeals originally concluded that the greenhouses could not be buildings simply because that they are not a permanent construction. The first error of law that we believe the BTA made is it's in its construction of the first element of a building. Generally, the statute contains 3 elements for a building. One is that it's a permanent fabrication or construction. The second is that it contains elemental structural elements or any combination thereof. And the third is that it has a structural integrity independent of the personal property or the persons that it shelters. And as the court will see from the BTA's decision, they entirely ignored the second 2 elements. But focusing on the first element, and as we all noted in our briefs, statutory construction is a de novo review at this court, therefore no deference is owed to the BTA's, what we're contending is an erroneous and unlawful construction of the statutes. In the first element of building, the statute actually reads permanent fabrication or construction. What the BTA did is that it applied the word permanent both to fabrication and also the word construction. And we believe that that is easily an error of law. I cited a case involving a criminal statute. However, it's applicable here in my opinion because the court concluded that when the word or is inserted between the 2 terms, the modifying term, the qualifying term that precedes the first substantive term applies only to that first term. Otherwise, you are completely ignoring the legislative intent with the use of the word or. So what the BTA did is they concluded that it had to be both a permanent fabrication and a permanent construction. And simply because the greenhouses are bolted with nuts and bolts, but they're not welded, the BTA said, oh, well, they can't possibly be of either a permanent fabrication or a permanent construction. But the greenhouses only have to be a construction. They do not have to be permanent when the definition is properly interpreted. And there's ample evidence in the record to show that they are construction of multiple items of tangible personal property that are constructed to form these massive greenhouse structures, which are very elaborate, complex structures. They have, they're located on approximately a 4 foot concrete foundation. They have walls. They have roofs. Occasionally they have retractable roofs. They have floors. And these of course are the second statutory requirement for a building, which is that it contains any, a combination of any of the elemental structural parts of the building. And the BTA just completely ignored this, as the court will see in its decision. It went no further than saying because it's not of a permanent construction or a permanent fabrication, simply because it can be deconstructed and moved, that it cannot possibly be a building or a structure. We believe that's the first legal error of statutory construction that the BTA engaged in. And then as to the third element.
So your argument is if the greenhouse could be classified as one of those three, the analysis stops right there.
No. I believe if the court were to apply fun time, which you do not necessarily have to apply it strictly under fun time and also under Metamora Elevator, but I think it would be worthwhile, and I think the court certainly could. But you would start with whether or not it meets any of the building structure improvement definitions in 570102, and then I think you can go on to whether or not it is otherwise specified as a business fixture. And we believe that the BTA also engaged in multiple legal errors of the construction of the business fixture statute as well. And the business fixture statute also essentially contains three elements. It must be an item of tangible personal property. It must be permanently attached or affixed to the land. And then it must primarily benefit the business, the business rather than the realty. And as to the first element, which is that it must be an item of tangible personal property, we're talking about the greenhouse itself. The BTA even acknowledged here that the greenhouses are constructed with multiple items of tangible personal property into a structure. But it essentially ignored the tangible item of personal property element altogether. And we've cited SSN2, which is the Court of Appeals case that relies upon the BTA's decision in Polaris. Both of those are talked about in my brief, but the 6th District in SSN2 distinctly recognizes that even upon a plain reading of the business fixture statute, that the item under consideration, which here is the greenhouses themselves, must be an item of tangible personal property. And I think the record is clear that it's multiple items of tangible personal property that are put together, in other words, constructed or fabricated to form these, nearly 4 million square foot of area under these large greenhouses. And
Wasn't
as
part of the reasoning though that you can move these without damaging the real property, you can take them apart, move them easily?
I don't believe that the fact that they can be moved is legally relevant to any of the definitions, in fact. Neither to the real property definitions or to the business fixture definition. The building or structure merely has to be a fabrication or construction, specifically for the building. It has to have elemental parts. The statute is silent as to whether or not it being mobile has any legal effect, and we believe here that it does not. As to the second element of the business fixture statute, the BTA concluded, and this was circular reasoning on their part, that because the greenhouses have remained in place for, some of them have been there for 40 years, that even though they couldn't possibly be of a permanent construction, that they were somehow permanently attached, which I don't think that conclusion makes a whole lot of sense. But if we're looking at only the proper construction of the word permanent in this statute as well, it doesn't have to be, it can be permanently attached or affixed. It doesn't have to be permanently attached or permanently affixed. But I think one of the errors, the other statutory error that the BTA made here in the business fixture statute is they went first to whether or not the greenhouses are used in Green Circle's business, and that was the sole focus of their analysis of the business fixture definition. And how we believe that the BTA got it wrong here is that they failed to recognize that the greenhouses are actually a use of the land itself. And what I talked about in my reply brief and where I believe this comes from is in Fun Time, the Supreme Court noted that in enacting the 1992, excuse me, in enacting the 1992 definitions that we're here talking about today, that the legislature reinstated what is called the appropriation to use test. And that comes from very, very old case law, but it was essentially a common law definition that has now been incorporated into the real property definition in the statute.
And I hate an argument, but
Sure.
Claus, you said you wanted to reserve time. Your total time left is 3 minutes and 54
Oh, my goodness.
seconds.
Okay,
now. So,
thank
I
you.
mean, you can continue if you'd
No,
like.
thank you, I'll reserve the rest for
I'll
today.
reserve the rest, okay. And counsel, you'll have 15 minutes, huh?
Thank you. May it please the court, my name is John Brolier. Together with my colleague Brian Smeek from Bricker and Echo, we represent the Appley property owners, Viola Associates, and Green Circle Growers. They're called collectively Green Circle throughout our briefs, and that's what I'll call them today. This case really turns on the fact that in 1992, 4 years after the old 1988 Green Circle decision, the legislature set out purposefully to revise and amend the statutes that define real property. At the same time, the legislature created a brand new category called business fixtures that had not existed before. So to the extent that the county and the school board appellants want to try and hang their hat on the old Green Circle case, that effort, I think, must fail. The Supreme Court had no occasion and no ability to decide whether the greenhouses are business fixtures because the category didn't even exist in 1988. When it decided the Metamora grain bin case, the Supreme Court of Ohio included the Green Circle case in its list of previous decisions that had illustrated why the definition of real property and personal property in Ohio before the 92 law change was what the court called elusive. And since that time, as I was preparing for today, I pulled up on Westlaw the old Green Circle case. It's got a red flag next to it, and it says it's been superseded by statute. That's the position of the property owner here, that when the legislature revises and amends definitions, that means something, and decisions that precede that law change are inapposite. Now, turning to the uniform testimony in this case, both sides experts, both sides appraisers, agree that these are mobile items They're bolted together. They are easily put up, easily taken down, and critically, they don't harm either the constituent elements of the greenhouse's parts or the underlying real estate. That was a factor in this court's most recent decision following Metamora, following Funtime, the Hoffman decision. And the fact that you could take this item away without harming the real estate, without harming the item, is one factor that suggests that we're dealing with business fixtures.
Council,
Yes?
and I know this is not a business picture, but I'm trying to understand how this all works in regard to like mobile homes, prefabricated buildings. Trying to think, even houses can people, because you really hang your hat a lot on the mobility factor. And I
Yeah.
understand it's not related to business picture per se, but.
Sure. That goes to our alternative argument, which is that because you can take down and move these things and reassemble them, they're not permanent and they're not real estate in the first place. My understanding of mobile homes, and this isn't in the record of the briefing, but that they are separately titled, and then that title is recorded with the auditor's office, and they pay tax on them. I think that where the analog breaks down with, a house that you put on a flatbed truck and move away, that house wasn't designed to be broken down to its constituent parts without harm to itself or the real estate. In contrast with the greenhouses, that's exactly what they're designed for. There's an active secondary market for these things, and the idea is that you unbolt them or you add new components on, and you haven't done any harm, and that's actually what they're designed for. A permanent house, you might be able to put it on a flatbed truck, but that's not what it's designed for. So I think maybe the analog comes apart there. But even if the BTA is right and the greenhouses are permanently attached, our position is that we still win under the business fixtures analysis. All the testimony is that if you were to be the owner of this property, say somebody bought Green Circle out and they didn't happen to be in the plant growing business, there's no alternative use besides growing plants and the specific plants that each greenhouse is for. They've got special greenhouses for orchids, special greenhouses for plants that grow on the ground, that are called ground cover, poinsettias. Each element of the greenhouse is particularized for the species and then the growth cycle of that species. There is no testimony that there would be a plausible alternative use for many, many, many acres of greenhouses. That reasoning comes from, again, Funtime, where the Supreme Court emphasized that the absence of an alternative use for the roller coaster station houses militated in favor of a finding that they're business fixtures. That follows from this court's decision in Hoffman, where there's no plausible alternative use for this special in-ground golf course irrigation system. So too here, the BTA found that they're, having reviewed days of testimony from both sides' experts, there's no plausible alternative use for greenhouses. They not only primarily benefit the business conducted through real estate, the BTA's factual finding was that they exclusively benefited. And that was conceded by Mr. Gear, the county's appraiser. I asked him on cross if someone were not going to be engaged in the horticulture business, what would happen to these things? Well, they'd be unbolted, taken down, moved across states lines.
What would happen to the foundations?
Foundations remain, and they are properly categorized as real property, both by our appraiser and in the BTA's decision. So we acknowledge that you can't pick those up and move them. The testimony is you'd have to break them apart. So those would remain behind.
What about the tax commission? There was an argument that the Ohio Tax Commissioner classifies greenhouses as real property.
Yeah, the tax commissioners promulgated what's called an information release. It continues to say that grain storage bins should be categorized as real property, even though the Supreme Court's held contrary in the Metamora case. I think if you look at that information release, it doesn't provide citations, but I think it tries to kind of recapitulate what various decisions have come out in that long line of cases in Ohio, both before the statutory change and after, that the Supreme Court called elusive. So I think it was an attempt to memorialize what are our tax classification decisions say. Our position is that it was wrong in Metamora and it's wrong here. returning to the discussion about the mobility and the temporary quality of the greenhouses, that's essentially uncontested. The county's appraiser is familiar with the 40-acre stand of greenhouses that was taken down, moved across state lines and reassembled. That just isn't permanent. And the testimony is that Green Circle itself has in recent years had certain of its greenhouses disassembled and sold on to other users. We elicited the testimony of the fellow from the company that did that work, and also the testimony from the family members who own and operate the property. This is just a different category of item from a permanent construction. But even if the county is right that permanent doesn't modify fabrication or construction, we still win under the business fixture analysis. The BTA made the factual finding that the greenhouses exclusively benefit the business, that there is no plausible alternative use of them other than in this business. And even if the BTA is right that the greenhouses are fixtures, we think that the clear evidence demonstrates that they're business fixtures, and so for that reason, the BTA's decision was reasonable and lawful. May I answer any more questions of the court?
Sorry, I'm looking through some notes.
It's fine.
Thank you very much for your argument.
Thank you.
Counsel, you have 3 minutes and 54 seconds left for your rebuttal.
Great, thank you very much. Regarding the 1988 Green Circle case, to clarify, we are talking about the exact same greenhouses. The older greenhouses, the poly hoop, they remain on the property today. So the greenhouses that the court held were structures or real property are the exact same greenhouses that we're talking about today.
But the
And
statute's not.
correct. And our position on that is that the legislature, had they intended for greenhouses to not be real property and be classified as a business fixture, they certainly would have said so in the business fixture statute itself. Among the examples that are in the actual business fixture statute, some of those directly address the Supreme Court's prior rulings. One of those is Pittsburgh Des Moines Steel, that were these large steel storage bins that stored liquid and the such. And of course, the legislature, in intending to directly reverse that, put storage bins and tanks in the definition. And as I cited in my brief, if you look at how the court described the process of fabricating, which that word, of course, is now used in the building and the structure definitions, the court described each and every single one of the elemental structural elements that are now found in the building definition. And they've used the word fabricate. It's our position that there is absolutely no legislative intent whatsoever that the legislature intended to reverse the 1988 Green Circle decision. Getting back to the alternative use, what I think is important about this, and I was starting to talk about the appropriation to use test, which was the common law test that it's now incorporated into the statutes. Under that test, it's whether or not the item in consideration is necessary or beneficial to the use of the land and the structures already thereon. The greenhouses are necessary and beneficial to the commercial horticulture use of the property itself. And we know that that is a use of the land because the legislature has actually said that commercial horticulture qualifies for the current agricultural use valuation, CAUV, tax reduction. So Green Circle is actually receiving a beneficial tax treatment already on the land that the greenhouses sit upon. And we believe that that you don't have to actually prove an alternative use because the use of the land itself, so in other words, 100 acres of 180 acres, these are not accessory structures to a different use of the property. These are the use of the property, and anyone else who wanted to engage in commercial horticulture could come in and use the property as is with minor modifications, but it could be used for a number of commercial and horticultural and agricultural uses. It's a beneficial use of the land itself, but I think we don't even necessarily need to get there because the greenhouses themselves are not tangible items of personal property. And just one final note about the Metamora case, there's been an attempt to draw many similarities about the portability and the movability and how these are constructed to the corrugated steel grain bins in Metamora. This is a very different case because the business fixture statute does not say greenhouses. In Metamora, the Supreme Court said, we need to look no further than to look at the actual expressly enumerated examples of business fixtures, and there was a storage bin and tank. So I think this case certainly involves a much more complex and detailed analysis of the statutes, and certainly this court is in the best position to do that, rather than the BTA.
And thank you. You
Thank you.
used your time. I want to
Thank you
thank you
very
both
much.
for your arguments on this probably simple factually case, but complicated legal issue case. You did a nice job arguing it. We'll take the matter under advisement, issue a decision in due course, and of course you'll receive a copy of the decision on the day it's released. You can also check the Ohio Supreme Court's website where the opinions are posted. Thank you again for your arguments.